artist that unfortunately passed last week. And we paid a tribute to him and to his family. He gave as a gift 20 large photographs to our court. So we have in this court, in a single public space, the largest collection of Sebastião Salgado's photographs. The two photographs that you have there are just on the environment. I say just because the other ones that are around the court, corridors and public space, are beautiful photographs of indigenous people. As you know, Sebastião Salgado photographed the whole world, from workers, migrants, wars, and the last part of his life, he dedicated to nature and to indigenous people. We are very grateful to him. In this panel, the first panel, we have as chair Christina Pak, who is the principal counsel of the Asian Development Bank. And more importantly, she is the mind and the hands behind not just an Asian Pacific, but global work with judges in respect to environmental protection and climate change. We are very grateful to Christina. She is amazingly competent, dedicated, well organized, and doesn't sleep. Because when I remember that I speak with her more than once per week, and often in odd times, she said, no, 2 a.m. is fine for me. And we are very grateful to you, Christina, to your dedication and your energy in making sure that the environmental rule of law and judges are in the right track. 3 speakers: Justice Martin Eifert from the Constitutional Court of Germany, a scholar well known in Germany and abroad. It is the first time that Martin, or Justice Eifert, participates in an event of the Global Judicial Institute on Environment, the SDJ, UNEP, and the other partners that get together for this type of endeavor. We are very pleased to have you here. It's a great addition to the global family of judges that study and work with environmental law. The other 2 colleagues are well known in this global family. Justice Bambang, who is the Dean of the Judicial Academy of Indonesia, one of the most extraordinary judicial academy that I'm aware of. Justice Mulyono is an expert on environmental law in general, with a particular focus on the protection of forests, and we have been collaborating for many, many years. And finally, we have Justice Zhaoxiang from the Supreme People's Court. He is the president of the Environmental Chamber of the SPC. For those that are not familiar with the major achievements that China has produced in the last 10 years, China has now over 1,000 environmental judges, green judges, as they are called, spread out all over the country. And it's the only country in the world to have a specialized division or grand chamber at the Supreme Court working only on environmental and climate change issues. And Justice Wu is the president of that chamber. With that very brief introduction, the floor is yours, Christina Pak.
Many thanks for that kind introduction, Chief Justice Benjamin. It's an incredible privilege for me to be part of this important event. So my deep gratitude to you and to your amazing team at the National High Court of Brazil. So this panel brings together esteemed justices from Germany, People's Republic of China, and Indonesia to help shed light on the judicial decision-making process in the context of simultaneous and interrelated sustainability challenges. Climate change and environmental problems are increasingly recognized as deeply interconnected and requires integrated solutions. So this means addressing issues such as climate change, pollution, and biodiversity loss in a holistic perspective, requiring judges to connect the dots and consider how these issues affect each other. Likewise, the law needs to be approached in an integrated way. For example, linking the Rio conventions with each other, international and national laws, environmental and corporate laws, and implementation that takes a whole of society approach. And this was very much highlighted in yesterday's panels in terms of an emphasis on implementation aspects as well. And judges are, of course, a key part of implementation of laws. So judges are key stakeholders in responding to the global crisis of climate, nature, and pollution, and they are essential in upholding, interpreting, and validating laws, as well as protecting the rights of the people and the beings that are affected. In considering these cases, judges navigate through incredible maze of facts, evolving science, intersecting laws, emerging stakeholders, weighing the multifaceted considerations to render decisions that shape environmental rule of law and broader ecological implications. And additionally, judges are also being called to adapt the law to respond to unprecedented challenges in these spheres. So now we will hear from the three justices on their perspective, coming from their areas of specialty. So first, I'd like to call to the screen, to the floor, Justice Martin Eifert of the Federal Constitutional Court of Germany, which court recently has played a significant role in climate litigation, including the landmark Neubauer case, which has focused on intergenerational justice. So Justice Eifert, the screen is yours.
Thank you very much indeed, Christina. Thank you very much for the kind introduction, and I'm very grateful for the opportunity to share some remarks with you. This is a great conference. Thank you very much indeed, Justice Herman Benjamin. It's great that you're convening this conference. In face of climate change, all courts are basically confronted with the same dilemma. On the one hand, climate change is a crucial challenge that puts some of the most basic fundamental rights massively at risk. It seems to be unlikely that the guarantees of national constitutions or international human rights have nothing to say on it. Courts are required to spell out what the promise of human rights protection means in this context. And this is in line with the traditional mandate of human rights courts, which includes safeguarding those fundamental rights which are jeopardized in the democratic process. In case of climate change, the fundamental rights of future generations are jeopardized as a result of the short-term bias of democratic processes. On the other hand, climate change involves long-term changes with uncertainty as to how precisely these changes will unfold and how they should be managed. The political branches are better equipped for such a management task than the courts are. Against this background, I'd like to give you a brief overview of the constitutional requirements that German climate policy must meet according to the German Federal Constitutional Courts. The requirements were spelled out in the already mentioned Neubauer case. The plaintiffs challenged the Federal Climate Change Act in the version applicable at the time. This was already a modern piece of climate legislation. Using the Paris temperature target as a basis, it imposed an obligation to reach net zero by 2050 and stipulated a binding obligation to reduce greenhouse gas emissions by at least 55% until 2030. The Act defined an emissions reduction pathway that included both time-specific targets as well as sector-specific ones. The Act thus defined mitigation benchmarks for specific time periods and for specific sectors, such as energy, transport, or building sector. For the post-2030 period, the annual mitigation targets were to be determined by way of ordinance, that is, by the government. In the framework of this conference, the court's reasoning is far more interesting than the specific results. The objective of the court's decision was threefold. One, to constitutionally enshrine the state's obligation to tackle climate change and its consequences. Two, to ensure that the way in which the state chooses to fulfill this obligation respects fundamental freedoms. Three, to ensure that the political branches are given the necessary leeway to design climate policy. It is important to notice that the court differentiated between the constitutionally required climate target on the one hand and the pathway towards achieving this target on the other hand. The chosen target must protect the environment and fundamental rights in a sufficiently effective way. This requires a continuous reduction in greenhouse gas emissions until net zero is reached. We are thus talking about positive obligations which the state must fulfill. The path towards net zero must be designed in such a way that the unavoidable freedom restrictions associated with mitigation measures are not distributed in a disproportionate manner over time. This is a matter of intergenerational justice. Let me explain the constitutional framework and how the court derived its conclusions. The basic law is does not only include fundamental rights, it also has a provision on environmental protection. Under Article 20A, the basic law requires that the state, quote, mindful of its responsibility towards future generations, quote, protects the natural foundations of life by legislative, executive, and judicial action within the framework of the constitutional order. Based on this provision, the court established key constitutional requirements to tackle climate change. Had there been no such constitutional provision on environmental protection, the court likely would have developed very, very similar requirements based on the duty to protect fundamental rights. But how much climate action does the Constitution actually require? This is obviously a key question. As a first step, the decision of the Federal Constitutional Court took the legislator at its word. In the Federal Climate Change Act, the legislator had committed to the 2050 net zero target as well as to the Paris temperature target, namely holding global warming to a maximum of 2 degrees Celsius, preferably 1.5 degrees Celsius above pre-industrial levels. Naturally, the Constitution is not merely a tool that is available to the legislator, rather the legislator is bound by its requirements. Therefore, the court examined whether the specification made by the legislator also complied with the constitutional requirements under Article 20A of the Basic Law. Constitutionally, there is no alternative to establishing that Germany be net zero in future. Given that any increment in greenhouse gas concentrations in the atmosphere further increases atmospheric warming, net zero must be reached globally, in other words, by every single state, before the temperature target can be reached. In contrast to this aim, it was significantly more difficult to establish constitutional standards regarding the mitigation pathway. What is the cumulative amount of emissions that Germany was allowed to emit prior to reaching net zero? Given that global warming is a function of the cumulative amount of global emissions, a scientific assessment can only define a global emissions budget in order to achieve the Paris temperature target. The IPCC has calculated this global budget, granted with various uncertainties which the IPCC has identified. But with respect to this global emissions budget, there is no internationally binding way of distributing it among states. However, the international community has agreed on a reporting and monitoring mechanism for domestic efforts as an incentive to increase ambitions in climate policy. The German Advisory Council on the Environment calculated a remaining national domestic carbon budget for Germany based on the global carbon budget that was calculated by the IPCC. It used a global emissions per capita approach. In its climate decision, the court considered this budget, based on a global emissions per capita approach, to be a sensible starting point, but not a fixed and absolute one, for calculating the remaining emissions amount that is still available for Germany. Two factors were critical in establishing the constitutional significance of this national emissions budget. First, given that climate change is a challenge that may only be tackled globally, Article 20A of the Basic Law also includes the requirement to undertake efforts to cooperate internationally with view to addressing this issue. Existing international efforts must be promoted and must not be impeded. Second, as we know, different distribution criteria are being discussed internationally. In comparison with other distribution keys, the per capita approach by the German Advisory Council on the Environment falls somewhere in the middle. Indeed, for an industrial nation like Germany, the chosen approach is actually rather generous, as it ignores historical emissions. With these two factors in mind, the court arrived at the following conclusion. If Germany's mitigation efforts were to significantly lag behind these requirements, this would undermine the commitment to ratchet up national ambitions that was agreed upon under the Paris Agreement. This, in turn, would be irreconcilable with Article 20A of the Basic Law. In conclusion, Article 20A of the Basic Law requires pursuing a mitigation pathway toward net zero that overall is based on the remaining domestic carbon budget. Assessed against the standard of 20A of the Basic Law, the challenged Federal Climate Change Act amounted to a borderline case. The cumulative amount of emissions permitted by the Act across all sectors would have largely depleted the remaining carbon budget by 2030. And by that point, given the mitigation targets that have been specified up to 2030, net zero would still be a long way from being achieved. The only reason why no violation of Article 20A of the Basic Law was established was that the remaining domestic carbon budget does not constitute a precise numerical constitutional standard, and that the court gave due regard to scientific uncertainties and to political leeway. Furthermore, for procedural reasons, the complaints could not be based directly on Article 28 of the Basic Law. They needed to show a violation of fundamental rights. The duties to protect offered a first step in this respect. The consequences of climate change, such as extreme weather events, heat waves, and others, are risks to health, life, and property against which the state must provide protection. Given that protection of these legal interests can entail not only mitigation measures, but also adaptation measures, and that existing uncertainties in calculating the remaining carbon budget and in assessing the consequences of the temperature changes needed to be taken into account, no violation of fundamental rights was established as yet back in 2021. However, a new constitutional concept that the court developed in its climate decision is the so-called intertemporal protection of freedom. Christina also already referred to it. Its purpose is to ensure adequate freedom over time during the course of the constitutionally required transformation process towards a net zero economy. A free order is not just about protecting life, health, and property, but also about protecting them in a manner that leaves as much freedom as possible to everybody. This requires that the constitutionally mandated transition to net zero is designed in such a way as to not restrict freedoms disproportionately. According to the concept of the intertemporal guarantee of freedom, constitutionally protected freedoms protect against the unilateral shifting of mitigation measures which necessarily restrict freedoms to the future. It's not permissible to simply put off solving the issue of climate change. Otherwise, at some point, an emergency stop would be necessary. In other words, rapid and drastic mitigation measures that would severely restrict freedoms. Given the constitutional requirements under 28 of the Basic Law and the duties to protect, net zero must be achieved by the time the emissions budget is depleted. the longer mitigation measures are postponed, the faster emissions must be cut to meet this constitutional requirement. The severe restrictions associated with such deep emission cuts would then, at this later point in time, be constitutionally justified because they would be necessary to achieve the constitutionally requirements, and they thus could no longer be successfully challenged. An effective protection of freedom rights thus requires that such severe restrictions of freedom that will is assumed to constitute an interference with fundamental rights. Such interference must then be justified and assessed as to its proportionality. In the case of emission burdens being unilaterally offloaded onto the future, it cannot be foreseen which specific restrictions will be necessary in future. But there is a severe and overall risk that freedoms will be severely restricted. This is what the decision referred to as an advanced interference-like effect. According to the court's climate decision, such an advanced interference-like effect in which the risk of restrictions of freedom is certain, even if their specific nature is not yet foreseeable, must be constitutionally justified in the same way as an interference with fundamental rights. Such an advanced effect must therefore be examined as to its proportionality. In conducting such a proportionality test, it is necessary to ask whether the measures currently in place offload mitigation burdens onto the future in such a manner that the later freedom restrictions are disproportionately severe when considering how much time is left overall. This aims at securing a reasonable degree of freedom throughout the transition to net zero. And this is precisely where the Federal Climate Change Act fell short. Put concisely, intertemporal guarantees of freedom require a reliable transformation pathway as a foundation for timely and orderly innovations and adaptation processes in society and the economy. This allows for the present protection of future freedoms. The Neubauer case fits nicely into international developments. If I briefly summarize in this broader perspective, I would like to emphasize the following conclusions. Fundamental and human rights law impose an obligation on states to guarantee an effective and rapid shift to a net zero economy. This requires taking rational and well-planned steps in terms of defining and communicating emission reduction targets. The chosen mitigation pathway, including the interim targets, must be based on the Paris Agreement. The question as to the precise content of relevant fundamental right obligations has not yet been fully resolved. The political branches are free to design the individual policy measures. Fundamental rights thus do provide an answer to the question raised by climate change. The courts act as a driving force for fundamental rights protection, but it is the political branches that will continue to steer the way. Thank you very much for your attention.
Many thanks, Justice Eifert. Actually, I haven't heard of, I mean, everything, I think we talked about connecting dots, but the dots do connect to the foundation, the Constitution. I thought it was really interesting, the intertemporal guarantees of freedom really gave that, in the context of future generations, I haven't heard it explained in that matter, but it's really interesting how the Federal Constitutional Court of Germany has explained the intergenerational right in that context. So thank you so much for giving us, more shedding light on the Neubauer case. Many thanks. So next, I would like to introduce Justice Wu Zhaoxiang, and he's the Chief Judge of the Environment and Resources Division of the Supreme People's Court of China, to share his insights. China has developed a comprehensive environmental judicial system with specialized adjudication bodies to handle environmental cases. And they have also made significant investment in judicial education in environmental cases over the years. Justice Wu, I'd like to invite you to the floor. Thank you.
好的，
Great, thanks.
尊敬的本杰明先生，尊敬的主持人，各位嘉宾，女士们、先生们、朋友们，大家好。
Ladies and gentlemen, good morning. It's great to have been invited and participating in this conference. Initially, I'd like to congratulate you on this event and having the opportunity to participate and share the Chinese experience. The theme I bring to you today is the Chinese experience to promote the protection of the environment and creating ecological civilization. In 2020, President Xi Jinping stated that China will enhance its nationally determined contributions, striving to peak carbon dioxide emissions before 2030 and work towards achieving carbon neutrality before 2060. Chinese society is united in its efforts to achieve this goal. Next, I will share with you the specific experiences and practices of the Chinese courts in systematically advancing integrated carbon reduction, pollution control, green expansion, biodiversity, and biodiversity conservation, while educating climate change cases. Continuously deepening environmental judicial reform and innovation to promote significant achievements in systematic ecological and environmental governance. So, as an active proponent and important practitioner of key international environmental governance rules, such as the United Nations Framework, Convention on Climate Change, the Paris Agreement, the Convention on Biological Diversity, the Vienna Convention for Protection of the Ozone Layer, the Montreal Protocol on Substances and the Deplete of the Ozone Layer, and the International Convention on Civil Liability for Oil Pollution Damage, China has always attached great importance to ecological and environmental protection. We have lost the audio for a second. One moment, some technical problems. So, President Xi Jinping has profoundly pointed out that protecting the ecological environment must rely on systems and the rule of law. He emphasized in the conference that we should insist in protecting the environment in the most rigorous form as a vital component of the legal framework for ecological environmental protection. Chinese courts has established over 2,400 specialized environmental and resources judicial bodies. This work has been done over 10 years.
这些专门的环境资源审判的机构和组织，集中处理生态环境的刑事案件、民事案件和行政案件。
These courts
听说中国法院已经形成了
cover the Supreme People's Court and High,
专业化的
forming the world's extensive and wide-range specialized environmental resource adjunction system. They encompass three major litigation areas of criminal, civil, and administrative law and administrative enforcement.
等生态系统，或者是以国家公园等生态功能区为单位。
Chinese courts follow natural laws and implement cross-administrative division jurisdiction and judicial cooperation for environmental and resource cases, including those related to climate change based on ecological systems such as watersheds, forests and wetlands, or ecological functional zones like national parks. China has been supported in the supportive role of judiciary in the modern environmental government system, enhancing collaboration with environmental administrative enforcement departments and improving the connection between litigation and alternative dispute resolution mechanisms such as mediation and arbitration. By utilizing a one-stop multi-facet dispute resolution litigation service system, we are promoting a multi-party co-governance structure for the ecological environment. Since the establishment of the Environmental Resource Tribunal of the Supreme People's Courts in June 2014, Chinese courts have adjusted 2,161,000 various types of ecological environmental resources cases. Among these, their social organizations, administrative bodies. If we categorize 303,000 cases related to ecological environmental resources security, 58,000 cases on environmental pollution and prevention and control, 664,000 cases on natural resource protection, 338,000 cases on biological resources and ecosystem protection, and over 620 new types of cases involving carbon market trading. In adjusting educating climate change cases, we have systematically advanced related fields such as biodiversity protection and also resource development and utilization and ecological environmental governance, and also the rural area. We have some values such as blue skies, clear water, and environmental protection. And the Chinese initiative, as it progresses to its profound changes, Chinese courts have accepted new types of cases, such as disputes of the dual carbon. In 2020, the Supreme People's Court issued the specification for the classification and statistics of environmental and resources cases for trial implementation, which lists climate change responses cases as one of the 5 major categories of environmental and resources case. The other court, in close connection with judicial practice, provides legal products to society, such as judicial policies, judicial rules, and typical cases to promote the continuous improvement of legal rules in the field of ecological and environmental resources. It has formulated and revised 22 judicial interpretations on ecological and environmental resources, released 45 guiding cases, and 453 thematic typical cases on ecological and environmental resources. In 2023, it guided all courts to apply the law. And each court in China has been working actively on these judicial services for the complete, inaccurate, and comprehensive implementation of the new development concept to actively and steadily promote carbon peaking and carbon neutrality, promoting actively and constantly typical cases, fomenting directives on disputes about climate change.
中国法院依法审判和执行碳排放交易案件，支持中国碳交易市场不断的发展
China
完善。
has the largest numbers of cases in its courts
温室气体
for the environmental theme
碳排放配额
and emission
公益诉讼案件，促成
as being a recurring theme.
主动购买了7300万吨
The
7300万元的碳
the
排放
business
配
that
额
have been taken to court,
相应的
they also buy carbon neutrality in the market.
进行，也推动了能源企业的绿色低碳转型。
This carbon market has been developed in a satisfactory fashion.
因违法施用受控消耗臭氧层物质被判处刑罚。
We've been following the way it's been working.
这个案件被收录到了联合国环境规划署
And to see if it's according to the law and if it's causing any sort of loss.
为全球环境法治提供中国方案。
So
21年
we expect to have interchange and cooperation internationally brought with the use of the Chinese court. So they have organized the World Conference for Environmental Justice in Huaning and established 3 major themes for environmental justice.
恢复性的司法措施、公益诉讼和多元化
Fairness and calm but differentiated responsibilities and respective capabilities. And third, the protection and sustainable use of natural resources and the principle of liability for damage. It also actively applies for the 4 judicial measures of preventive and restorative judicial measures.
先后举办了环境法治
In the past 3 years, we have successfully held international seminars on environmental rule of law and green development, the Green Silk Road in the new era, and judicial response to climate change, producing important outcomes such as the Beijing Consensus. These initiatives offer judicial know-how from China.
目前，联合国环境规划署数据库已经专门设立了中国
PNUMA included in a session dedicated to its database, which includes 45 typical Chinese cases and 8 annual reports on China's environmental and resource judiciary,
为全球环境治理提供的相应的
highlighting practical experiences to the world.
中国法院在审理气候变化案件中，一体推进生态环境系统治理方面的一些做法的简要的介绍，希望对大家有所帮助。
And these are my observations
能听到
on the experiences and practice of the Chinese courts. I'm very thankful for participating, and thank you very much for having me here.
Thank you, Justice Wu, for sharing just a snapshot of China's rich jurisprudence and the various adjudicatory bodies for hearing environmental and climate disputes, including emerging carbon market disputes, which was really interesting. So next, I would like to introduce Justice Bambang Mulyono. As Chief Justice said, Indonesia has one of the most impressive judicial education centers, and they actually have been leading on judicial capacity building on environment and climate issues for a long time. So Justice Bambang, please share your perspectives on how Indonesian judges have been integrating considerations of climate change, biodiversity laws, water resource management, pollution control into the judicial reasoning, as well as remedies. So we look forward to hearing from you. Thank you.
Thank you, Christina. Thank you also for Justice Benjamin, panelists, justices, colleagues, and also our friend around the world. it is an honor and privilege for me to share experience with you to speak on the topic integration of climate, biodiversity, water, and pollution in judicial decision making. As we gather here, the world is confronting an unprecedented conflict of environmental threats. There are climate change, biodiversity loss, pollution, and water scarcity. These are not isolated problems. They are interconnected, compounding, and deeply embedded in the fabric of justice, human rights, and sustainability. Next, please. Oh, sorry. And as judges today are increasingly asked for to adjudicate cases that test the boundaries of environmental law, constitutional rights, corporate accountability, and even the future of generation yet unborn, from the Urgenda cases in Netherlands, the Clima, Seniorinen in Switzerland, and landmark judgment in Brazil, India, Pakistan, Philippines, and many countries. We are witnessing the rise of climate and environmental jurisprudence across the globe. In the judicial mandate in the planetary crisis, there are negative things that climate change, biodiversity, and pollution is the most important that we must know about the planetary crisis. But we also the positive thing, environmental governance, a good rule regarding to the environmental rule, and also protection of international rights is a part of many norms and many principles that implement in the environmental law. So the interconnected environmental crisis, climate change, biodiversity loss, pollution, and water scarcity, it's make a frame for judiciary's role as a protector of intergenerational rights and environmental governance as the good thing. And we can establish the courts are increasingly involved in reviewing the legality of government and corporate product affecting this ecological domain. Next, please. So what is the integration in the judicial practice? I think there are 3 points of the judicial reasoning that implemented by environmental judges as using ecological and scientific principle in the interpretation of law. Public must know about what is the reason for the judges to make an order that's related with environmental cases, and also implement the remedies. And this order issuing not just for compensation, but also for restoration, prevention, and injunctive relief. This is a part of the injunction that's to avoid the more damage for the environment. And that is a procedural innovation. We learn about innovation by some of Supreme Court, for example, to make regulation to improve the procedural law to implement the environmental rights to protect the nature and also for human beings. This is adjusting the legal procedures to allow better access to justice in environmental matters, such as broader standing and relaxed evidentiary thresholds. And climate change and judicial review. I think courts enforce a climate commitment, such as those under the Paris Agreement, and implement of precautionary principle, integration, intergenerational equity principle. This allow judges to act even amid uncertainty. And sides of international example, as I mentioned before, for example, the case in Kaima Seniorin versus Switzerland in 2024, Urgenda cases in Netherlands. So Indonesian example also a court ruling on forest moratorium and restoration showing local relevance. In Indonesia, we too have begun to integrate environmental principle in court decision through forest moratoriums, watershed protection, and community rights. However, the road ahead requires deeper integration of science and legal reasoning, of ecological restoration in remedies, restoration of the environmental damage, and intergenerational equity in our moral and constitution framework. And it is also implemented by in the judgment as a legal reasoning to more understanding by the public and the company to understand about the court order. In the biodiversity and ecological integrity, in this term, environmental impact assessment (EIA) must consider biodiversity. For example, we learn about a Grey and Minister of Planning in Australia cases. There are recognized and then considering about EIA as a part of the in the judgment. And also courts can issue injunctive relief to prevent irreversible damage. This is some cases in Indonesia and also country where there are many company, mining company. So this to cancel the destructive in the coal mining area. This is to prevent irreversible damage. And the third is emphasizes restorative justice through ecological remedies like reforestation, to clean up the area where this area is damaged or degradation. So this is important for the court decision to restorative through ecological remedies. And about water governance and rights. Water governance and rights accept water as a human rights. We learned about a case in Pakistan, Asghar Leghari case. That's this court decision also make a legal reasoning about right for the people about water, or clean water, and health water as a part of human rights. And then watershed-based legal rationing. Just introduce watershed-based legal rationing for more ecological coherence in decision. And about transboundary cooperation. This is important. Set as a transboundary water law, where we can learn the Kapchikovo Nakimaros project case in International Court of Justice, relevant for international cooperation. And also rising transboundary cooperation implement also by Indonesian people were sued to the company in Australia through Land and Environmental Court in New South Wales in Sydney, and this is a procedure using class action. And the pollution control and corporate accountability. Pollution control and corporate implement in the principle of precautionary principle, save the burden of proof to polluters. We can learn from the cell cases and RVE cases that implement of precautionary principle, and then scientific evidence increase support linking emission to specific harm. We learn this case against cell and RWE. And court order remedies beyond monetary compensation, including clean and corporate reform. This is important to restoration of the environmental damage. And how to enhancing environmental justice through the judiciary. However, Indonesia is a civil law system that's not legally binding with jurisprudence and not implement of stare decisis. But in implementing judicial activism, judges also can use decision by abroad court. So we learn in many cases that implement in many countries, and we can use the international principle, and also we can use the legal reasoning by international court decision to enhancing environmental justice through the judiciary. Public trust, the doctrine as a public trust and ecological integrity. We can learn about the Montana case in US, and ecological integrity, recognizing ecosystem in legal interest, advocates for technological tools. For example, right now we can judges must understanding about technology. For example, we can use AI tools and data platform as a part of how to make a good analysis and a good reasoning for making of court decision. And also collaboration, judicial climate network, because this is a common issue. For example, in ASEAN country, Indonesia, with members of ASEAN countries, with collaboration in education, training, workshop, and also share of best practices, knowledge among judiciaries in ASEAN countries. For example, under the Council of ASEAN Chief Justices, CACJ, we make a working group in judicial and education training, and also working group in climate change. So we can share knowledge, share best practices among judges in ASEAN countries. Usually, one time we in-person meeting, but right now during 2 and 3 years, we make many workshop FGD using online. I think this is good for judges to share experience, share knowledge, and also among judges in ASEAN countries, we make some the concept, the draft of guidebook to handle environmental cases, including climate change issues. So, what is the Indonesia rule and reform direction? Indonesia, we have special chambers on environmental law, certified environmental judges, and therefore, in my office, we make a environmental law in judicial education. Some of the training is related to the environmental cases, procedure, and also workshop and short training in specific case. We learn about case in Indonesia and also cases from another country. This is Indonesia strategic response to establish of a specialist environmental law chambers. So incorporation of environmental law into judicial training curriculum, we make some project in the to make a good curriculum, and every year we make evaluation. Participation in ASEAN dialogue. This is a part of collaboration and judicial dialogues in ASEAN country. So this is fostering regional alignment on judicial approach to environmental law. Conclusion, as personal, every single judges, they must understand how to emphasize the transformative role of judges and as a proactive steward of ecological justice, and from neutral arbiters to proactive stewards of ecological justice. And as a system, a judicial system, we ensure that conflict environmental and human rights law, and then accountability we must is enforces integration of environmental and human effective and accountability mechanism, and legacy where future generation inherit livable planet. This is also implementation of intergenerational equity. I think this is all my presentation. Thank you. Back to you, Christina.
Thank you, Justice Bambang. Thanks very much for that very comprehensive presentation. I really liked you ending in a high note. Really, I've noticed a lot of the opportunities that the Indonesian judiciary has took advantage of, such as environment, specialized courts, judicial training. I think what I got out of the latter part of the presentation is really judicial education and also knowledge sharing among regional and global judiciaries are really critical. If other justices, Justice Wu, Justice Eifert, have any comments on some of the opportunities or trends in judicial decision making, if you'd like to comment on, I'd like to invite you to make any comments on that before we move to Q&A. Thank you.
Christina, if I may, I have a question from a participant to Justice Eifert. And the question is the following. because I know you have to go back to your court sitting. So I'll ask the question now. The question is about the relationship between climate law and the traditional environmental law. It's a question from Amanda Aboud. The European Court of Human Rights has stated that their environmental case law is not applicable in climate cases. This places us in serious danger of not applying the protective environmental law principles that have been developed by the jurisprudence, such as non-regression and other environmental law principles. What do you think has motivated the court's position? And do you believe this might be followed by other national and international courts?
Thank you very much for the question. I'm not in the position to speculate about the motivation of other courts. Therefore, I would like to refrain from just sharing what I might be thinking about what the motivation of them could have been. But I think that effective climate change regulation and the combat of climate change indeed has specific features. And it is one question whether or not you apply the traditional environmental law principles on this issue. But it's another question just how to design a legal framework that can effectively combat climate change. And I don't think that it's the crucial question whether or not applying environmental law principles, because if you look at constitutional law, then any infringement of constitutional values is protected, and we know the duty to protect against any kind of climate change consequences. And therefore, whether or not you apply environmental law principles, the state is obliged to protect effectively these constitutional values. And whether you design a framework that specifically addresses the climate change issues, or whether you derive it from general environmental law principles, does not make such a difference. And as the problem is well noticed, and as courts do address the issue, I think we should focus on the effective measures against climate change, and the matter of how we sort of make a systematic legal design or how our doctrines are construed is not of primary importance. So that's sort of an answer that's avoiding any speculation about a foreign court. I'm sorry, but I think it's unfair for one court to speculate about the motivation of another one.
Well, thank you. If I may, Christina, back from this side of the world in Latin America, I would say that the protection of climate comes within the protection of the environment. And the constitutional provisions in different Latin American countries, and especially framework environmental laws, the so-called National Environmental Policy Acts, they protect the environment in a holistic manner, and it specifically mention climate. Therefore, from that perspective, and again, I cannot speculate about what other courts have decided on that subject, but if the point of departure is the environment as a holistic construction and moving into the elements of the environment, climate is one of the elements of the environment together with water, soil, oceans, water, and so on. Wildlife, forests. The second point is that usually, with the exception, there are exceptions, but usually countries that in Latin America that have enacted climate laws, specific climate legislation, those specific laws make a reference to environmental or general environmental law. And in this court, in my court, we make no distinction. We use the environmental law principles in all areas of environmental law, unless it's explicitly prohibited or excluded from a particular piece of legislation, which is not the case. That's what I could add to this debate.
Excuse me, Justice Benjamin, may I just add one point?
Yes, please.
Thanks very much. I was talking about the constitutional level. At the level of specific environmental law, of course, in Europe, climate change is also included in many, many environmental laws, and therefore it goes without saying that a lot of laws apply to matters that also contribute to climate change, and it is expressively named in a lot of European legislative acts. And therefore, at the level of environmental law, climate change is included in the sort of overall system of environmental law. I was just talking about whether or not applying principles that are applied to traditional environmental law issues to climate change as a new phenomenon. That's at the constitutional level, it's a different question. Yeah. Just to avoid any misunderstanding, I'm sorry for this.
And also, in addition to what you have said, and I think we are all on the same page on this, it's possible that from a pragmatic point of view, a particular principle of general environmental law might not be applicable entirely in the climate change field, because there are particularities in climate change that do not exist in other areas of environmental law. Of course, in other areas of environmental law, we do have transboundary environmental resources like water, wildlife moves, and so on. But climate change is of a different nature. It's global. And I think and I'm just speculating here in abstract, but there might be cases in which there will be a mismatch between the original design of a particular principle or even instrument in general environmental law, and it would not fit entirely within the complexity and the particularities of climate change. I think we are on the same page here on this. Christina, back to you.
Thank you. There's one question from the audience, from David Boyd. Basically, he's saying that the UN General Assembly recognized the right to a clean, healthy, and sustainable environment in 2022. And he would like to know if there have been any judicial decisions in your countries applying this fundamental human right since 2022. If any of the justice could answer this question, including you, Chief Justice Benjamin. Thank you.
Christina, I don't see Justice Wu in the group anymore. I wonder if there was a technical problem on his side, because on this side, everything is working very, very well. But perhaps the other colleagues could try to address the questions posed by Professor David Boyd. As you know, he's one of the leading scholars in the world on environmental law and a former rapporteur for the environment in the Human Rights Council. So perhaps Professor Eifert and Justice Bambang could address those questions.
Thank you very much for the question. I'm not aware of any judgment that's referring to it, and I think it's as it's a very broad obligation. In most conflicts, people refer to the much more specific European and national legislation, and therefore it wouldn't give any further protection than is already given by the principles of environmental law at these levels. And therefore, I think people have not become even aware of the fact that this might be an additional point of reference for in any conflict.
Yeah. For Indonesian, we learned in many court decisions that because in Indonesia implement of constitutional rights that there are including human rights, and one article in our constitution that access to the environmental the health environment and the clean and health environment is a part of the human rights. So this is also implemented in environmental law protection. So for the judges, it's not difficult to implement about how to protect the human rights, because in the basic, because we are applying a civil law system that we have an act related to how to protect the human rights related with environment. Back to you too, Christina.
Okay, thank you. Are there any other questions from the audience, Justice Benjamin, or anybody else?
Yeah, David Boyd asked a general question. I don't know if you have read it. At the recent advisory opinion proceedings on climate change at the International Court of Justice, Germany, Indonesia, and China were among the small number of states that argue that the right to a healthy environment does not exist in international law. What were the reasons for this retrogressive approach? I wonder if any of our colleagues would like to address that, and I might add one word or two. If not, what I would like to say is that often the position of countries in international bodies are different from the positions that the countries themselves adopt internally. There are countries, including Brazil, that are very skeptical of what Brazil and other countries see as the internationalization of the environmental debate, the notion of sovereignty over natural resources. This goes back all the way to the beginnings of environmental law, and that's one of the reasons why we don't have a convention on forests, for example, that was proposed in 1992 during the Rio conference. Brazil and Malaysia opposed that, and we ended up with the non-binding principles that exist today. As a judge, that's as much as I can go, and only stating what is common practice. Often we are surprised by the official position taken by countries in those international fora. And it's not just in environmental law. We see that in other areas of law as well. Do we still have time? No. No, we need to. We are 1 minute already past the hour. I would like to thank our very competent chair, who will continue as chair, to thank the three distinguished judges, Justice, in fact, Justice Martin Eifert, before he was, and perhaps he still is, with a leading university in Germany, and he was the director of the law school in Berlin, Justice Bambang Mulyono, and Justice Zhaoxiang. To all three, my word of gratitude, and I do hope to see you very soon. And Christina Pak, you stay. We will immediately start panel number 4 with Justice Prakash from India and Justice Damares from Costa Rica. Thank you very much. Bambang, if you want, you can stay. No problem.
Yes, yes. Yeah.
Yeah, please stay. I don't see Justice Damares Vargas with us. Yeah, she's connecting. So let's give her one. There she is. So again, it's a great pleasure to welcome you. The chair of this panel is Christina Pak. All of you know her. I have already made a brief introduction of Christina Pak at the opening of today's part of the symposium. In this panel, we have Justice Prakash Shrivastava, the chairperson of the National Green Tribunal of India. And before that, he was a member of the Supreme Court of India. Very distinguished and well-known scholar and expert in environmental law. The second speaker is Justice Damares Vargas from the Supreme Court of Costa Rica. We have just recently re-elected her as in the Summit of Chief Justice of Ibero-America as the chair of the Environment Committee of the Summit. Damares Vargas is, again, very well known for her work in Costa Rica and in the whole region. And she's a frequent participant in the events that we organize, a member of the board of the Global Judicial Institute on the Environment. And it is a great pleasure to have both of you in this panel. Christina Pak.
Thank you, Chief Justice. I am a poor substitute just for Justice Malla, who can't make it, but I hope I can help out. So, first, I'd like to invite Justice Prakash to share some of the cases coming from the Indian Green Tribunal, which is known to be one of the most progressive and innovative courts. So, Justice Prakash, the floor is yours. Thanks.
Yeah, thank you, Christina, and thank you, Justice Benjamin. My greetings to all the panelists and participants. I'll be covering the cases decided by National Green Tribunal, the Supreme Court of India, and also other judicial forums all over the world. But I'd like to start with the words of former US President Barack Obama. He has said, I quote, "We are the first generation to feel the effect of climate change and the last generation who can do something about it," unquote. These are not the words of caution, but they call for immediate action today we are witnessing not just rising temperature, but also rising expectations of future generations who look to our legal system for protection, accountability, and hope. The past decade has seen a surge in climate litigation, not only in volume, but in depth. The cases now question state inaction, push corporate responsibility, and link environmental degradation to human rights. One of the most important fundamental trends noticed in climate judgments is that the courts across the world are increasingly framing climate change as a human rights issue. Legal systems are now treating state inaction or insufficient action on climate change as a violation of fundamental human rights. An important judgment reflecting this new wave of climate litigation is the case of Klima Sandrinen versus Switzerland. In this case, the litigants were a group of elderly Swiss women calling themselves the Klima Seniorinnen, a senior woman of climate protection, who approached the European Court of Human Rights after experiencing increasing severe and frequent heat waves that endangered their health and lives. They argued that the Swiss government inadequate climate policies violated their rights under Article 8 of the European Convention on Human Rights, which guarantees the right to respect for private and family life. In its ruling, the court held that the states have a positive obligation to implement effective climate policies aimed at substantial and progressive reduction of greenhouse gas emission. It emphasized the urgency of action by observing that, I quote, in order for this to be genuinely feasible and to avoid a disproportionate burden on the future generations, immediate action needs to be taken and adequate intermediate reduction goals must be set for the period leading to net neutrality. There is also a recent landmark judgment of the Supreme Court of India in the case of M.K. Ranjit Singh and others versus Union of India, popularly known as Great Indian Bustard case. In this case, the litigants had challenged developmental clearances granted without adequate ecological safeguards in the biodiversity-rich Indian states of Rajasthan and Gujarat. The clearances had threatened the critically endangered Great Indian Bustard and other bird species due to overhead power transmission lines. In addition to environmental protection, the court addressed the core issue as to how climate change directly affects human rights, particularly the constitutional rights to equality and right to life under Article 14 and 21 of the Constitution of India. The Apex Court of India held that without a clean environment which is stable and unimpacted by the vagaries of climate change, the right to life is not fully realized. It recognized that the vulnerable communities disproportionately suffer from the environmental harms, underscoring that climate justice is a constitutional imperative. This judgment profoundly impacts India's environmental jurisprudence by empowering citizens to enforce their rights against environmental damage, affirming the inseparability of human rights and environmental protection in the climate era. Another set of important case laws is in youth-led climate litigation. Around the world, young people are increasingly turning to the courts to demand stronger climate action, invoking the rights of future generations who will inherit the planet. The example of youth-led climate change litigation in India is the case of Ridhima Pandey versus Union of India, which has been decided by the National Green Tribunal and now pending before the Supreme Court of India. This case symbolizes a transformative shift where young citizens are no longer spectators, but are active participants demanding justice and accountability. In this case, a 9-year-old petitioner had come with a plea that under the public trust doctrine, India's Paris Agreement commitment and environmental laws, a greater governmental action was urgently required to mitigate climate change. The case invoked principles of sustainable development, precaution, and intergenerational equity. This case emphasized that the children and future generations have a constitutional right to a healthy environment, and they are disproportionately vulnerable to the climate impacts such as heat wave and malnutrition. The petitioner had sought court's order to integrate climate concerns into environmental impact assessment, establish a national emission inventory, and create carbon budget. The National Green Tribunal emphasized on the state's duty to formulate and enforce robust climate policies, recognize the direct link between environmental governance and the fundamental rights of the citizens. The young petitioner also appealed to the Supreme Court of India, and in 2025, the Apex Court of India issued notice in the matter, appointed amicus curiae, and directed the government to compile relevant carbon emission rules, while recognizing the need to scrutinize the enforceability of international climate commitments and to incorporate climate-specific mandate into national laws. There is yet another set of recent case laws that are against private companies, especially major carbon emitters like corporations for climate harms. A landmark movement in this emerging trend came when the District Court of The Hague in Netherlands delivered a groundbreaking judgment in Royal Dutch Shell case. The case was brought by Friends of the North Netherlands, along with several Dutch environmental NGOs and over 17,000 citizens. The plaintiffs allege that the Royal Dutch Shell's business model violated its duty of care under Dutch civil law and its obligation under Article 2 and 8 of the European Convention on Human Rights by contributing significantly to climate change and thereby endangering the right to life. An important judgment, the Hague Court, while recognizing that protection from dangerous climate change is a human right, held that the Shell has a legal obligation to reduce its scope 1, 2, and 3 emissions in line with the Paris Agreement. This judgment marked a transformative movement in climatic jurisprudence by holding private multinational directly accountable for aligning its business practices with global climate goals and has set a global precedent for corporate climate responsibility. There is yet another landmark judgment of the Supreme Court of India in the matter of Vedanta Limited versus State of Tamil Nadu. It is delivered in February 2024. Vedanta Limited, a major industrial conglomerate, was the litigant challenging stringent regulatory restrictions imposed due to its violations of environmental norms, specifically groundwater pollution, deteriorating air quality, affecting local communities' health and livelihoods. The core issue before the Supreme Court of India was whether industrial activities causing clear and scientifically proven environmental harm could continue without restraint, especially when such harm infringed upon the constitutional rights to a safe and healthy environment. The court had firmly that while industrial growth is vital for economic progress, it must not come at the expense of environmental protection or constitutional guarantee. Corporate environmental accountability is an indispensable condition for economic legitimacy. The judgment's impact is profound, establishing that courts will hold corporate entities accountable to uphold ecological rights and public health, ensuring that economic development respects constitutional values and climate resilience. In another case, there's Hindustan Zinc Limited versus Rajasthan Electricity Regulatory Commission. It's a pivotal moment in India's journey towards global corporate accountability in the fight against climate change. In this case, Hindustan Zinc Limited, which operated its own captive power plants, challenged the rule made by the Rajasthan Electricity Regulatory Commission in 2007 and 2010. Now, these rules require all the electricity producers, including those with their own power plants, to buy a certain amount of power from the renewable source. The main issue was whether such private producer could be forced to follow these rules, or if their economic independence protected them from such obligation. The Supreme Court of India stated that, I quote, "The economic freedom to generate electricity does not override the obligation to contribute to sustainable development and the larger public interest in environmental protection," unquote. The Supreme Court upheld the rule, holding that promoting renewable energy is not just a regulatory decision, but it's a constitutional duty. The court linked the right to a clean environment to Article 21, that's right to life of the Indian Constitution, and also referred to Article 48A and 51AG of the Constitution, which call on both the state and citizens to protect the environment. The ruling made it clear that private companies, not just the government, must contribute to the climate goals. These cases underscore the growing judicial vigilance with respect to the emerging trend in climate change litigation. This judicial journey reflects a profound transformation in how legal systems engage with the climate crisis. From recognizing the rights of vulnerable population and future generation, to holding the states and corporations accountable and integrating cutting-edge scientific evidence. These developments collectively advance a jurisprudence grounded in justice, equity, and sustainability. In conclusion, the emerging corpus of the climate case law, national and international, reflects a jurisprudential awakening. The climate litigation is no longer a peripheral endeavor. It's now central to the legal architecture of environmental governance. As jurists, we must ensure that law must not remain fossilized. While the planet is on fire, it must evolve, not merely to protect the present, but to secure the future. Thank you. Thank you so much. Over to Christina.
Thank you, Justice Prakash. Thanks for your inspirational presentation. It was really interesting to hear the parallels you drew between the Indian jurisprudence and
É
other
muito interessante
countries.
ver a relação entre a jurisprudência indiana e a de outros países
And
e
shedding light on the reasoning
jogando
behind
luz
Indian cases. So many thanks.
sobre tantos
So
casos
now,
interessantes
we're
indianos.
going
Muito
to
obrigado. Então, agora passamos a
Chief
palavra
Justice Damares Vargas. Thank you.
à ministra Damares Vargas. Obrigada.
Reciba un especial saludo. Gracias, ministro Benjamin, por darme el honor de ser parte de este grupo de magistrados y
Thank you,
expertos
Minister
ambientales sobre el
Benjamin,
planeta, de quienes he aprendido mucho ayer y hoy. Costa Rica es un país
for
pequeño,
joining
rico en
together our
información
justices
sobre
from all over
y
the
medidas que se han
world.
tomado.
I learned a lot today. Costa Rica
Cuenta actualmente con
is
una altísima
a small
biodiversidad,
country, but due to its
pero de
geographic
vez en cuando Costa
location,
Rica tiene
and
una
there's lots of
cobertura
special measures to
forestal
be made. And
considerable,
currently, there's a lot of
dado que
biodiversity. In
el 55
2024, we had a
51%
considerable
de este
forest
territorio
coverage, reaching
y además
54%
por
of
reserva
the
o zona
surface
de
of the
extensión
territory.
protege al
Beyond this, it can
26.7% de las
encompass
especies mundiales en
such a
solo
small
1%
in such a
de
small
su
space,
territorio.
only
Esto
six
dice mucho
we
de
have
lo
only
inmenso
1% of the world's
compromiso que
surface,
tiene
but we
Costa
have
Rica con el cuidado
6.4% of the
ambiental
species.
del
This shows a lot
no puede dar un
for
paso
our
atrás.
effective
Costa
commitment
Rica
for the
cuenta con
environmental system. So we can't
personal
stop there.
ambiental
In Costa
especializado
Rica, we
en materia
have a
administrativa
specialized
internacional. Este tribunal
administration
ambiental
for the
desarrolló
environment. And I
ese
can
medio
say
ambiente y
that this
energía
is an
en una
important
autonomía máxima.
aspect of the
Experiencia
administration that's a part of the
internacional
Ministry of Mines and
en
Energy.
especialización de
This
tribunales ambientales en tareas
institution
de
works for
interpretación
the
legal, la
specialization of
Constitución
environmental
y la
courts, and this happens through a
jurisdicción
variety of different legal devices.
administrativa
This
en materia de
corresponds
Estado,
to
ambiental,
a
agraria y
contentious
social participación de
jurisdiction
orden
which
constitucional. Costa
joins
Rica
the
actúa
penal aspects with
imparcialmente
constitutional
al
courts. In Costa
justificar
Rica,
la
the
Policía
judicial
General y
model
la Fiscalía
incorporates
Ambiental
jurisdictions,
Especializada,
general
la Policía Técnica
monitoring, and with
y que conforman
specialized
unidades de
environmental
investigación
monitoring from our
ambiental
technical
en
scientific
delitos
police, which includes the
ambientales
environmental investigation
como
police
crimen
for
organizado,
environmental crimes, which are cataloged
expropiación
as
y
organized
la
crime.
visión que se puede
This
tener de estos
changed
delitos
the
ambientales
vision that we
es
had
basada
on
en la
our
República Agraria
environment, our
para
territories. Not
personas
only that, but we have
de escasos
free
recursos.
public defenders for
Costa Rica
people who are in
recalcó ayer
situation
su jurisprudencia,
of
pues desde
scarcity of
1990
resources.
hasta la actualidad,
Beyond this, ever
la
since
jurisprudencia
1990 until today,
constitucional
we
es
have a
vinculante y
jurisprudence
asume
which is
obligatorios en nuestro
constitutional
país,
and which is
afirmando que
binding.
los convenios
And it's
internacionales
compulsory in
de
our country,
derechos
saying
humanos
that international
ambientales
conventions of
son
human rights and
supraconstitucionales,
environmental
es decir,
rights
están por encima de la
are
Constitución
super
política.
constitutional. That it
La
is, they are
jurisprudencia es
above
vinculante
our
y la
constitution.
tarea para
And this
tratar este
binding
sistema de
jurisprudence
control de
is
constitucionalidad es
held
centrado
in such a way that there is
facilita el
a
proceso de que la
concentrated
legislación interna pueda
constitutionality
estar
system. This
definitivamente en línea no
facilitates
solamente
a
con la
process in which the
Constitución
internal
política, sino
legislation
con
must
los
be aligned not
estándares
only with our
internacionales
political
de derechos
constitution, but
humanos.
with our
Pero ¿por qué es
international
relevante
human
el
rights
caso
and
de Costa Rica, la
environmental
Constitución política
conventions. Why is this
especialmente
relevant?
regula
Because in the
la
case of Costa
legislación
Rica, our political
amplia para que
constitution
cualquier persona
regulates the
pueda denunciar
legitimacy,
daños
the
ambientales.
wide
Esto
legitimacy
incluye
so that
también
any
los
person
derechos de las
can make an
futuras
accusation of
generaciones,
environmental damage. This
incluidos
also
el
includes
derecho a un ambiente sano
intergenerational
y
rights, and
ecológico
especially in the
sustentable,
environmental
enfocado
rights, the
siempre
right
en el
to a
desarrollo
healthy environment
sostenible.
and to
Esta
an
nueva
ecologically balanced
constitución
environment focused on
incluye dos
sustainable development.
aspectos
And this
que se
constitutional
definen desde los
reform
años 90.
incorporated
Primero,
aspects
el
which
sitio de los registros
defined
de la
throughout the
jurisprudencia
90s,
costarricense ya no viene
and
incorporando de sus
this was in the
normas
early
de
90s when we were
pronunciamiento.
creating
Hemos ido
our Costa
avanzando y
Rican
convirtiendo en nuestra
constitution. We have a variety of different devices. So we have
normativa
internal
nacional
norms
que
which were
establece un
recently
proceso
approved,
ambiental para
establishing
asegurar
an
los usos
environmental
ambientales de
process
trámite
that
prioritario en
is
relación con
preferential
los
so
demás
that they are
elementos ambientales.
priority
Una agenda muy
cases,
eficiente basada en la
and they are in
reparación
the
y la
environment.
recuperación
Therefore,
que
we
hace
should have
posible la
efficient resources
adaptación al cambio
based
climático.
on full
Bajo
reparation.
una
So what did
política
Costa Rica do to
nacional
adapt to
de
climate change? We
adaptación al cambio
adapted to a
climático
national policy
2018-2030,
climate
que
change
define
ever
los
since
retos fundamentales
2018.
para
The plan
mantener
is from 2018 to
informadas todas las
2030. This is a
autoridades y
fundamental instrument
organizaciones,
to
inclusive en la
keep everyone
judicatura y en las
informed for the
partes
decision
interesadas,
making,
que
especially
facilita la
in the judicial
participación de los
system, and
ciudadanos.
especially
Voy a
to facilitate the
mencionarles
participation
algunos de las
of citizens. So
jurisprudencias
beyond
que
this, I'd also like
actualmente
to
ofrecen
mention
los
some
tribunales
jurisprudence which has been
ambientales
issued in our
considerados
courts
relevantes y
regarding
que se
the
han
environment that we
utilizado
consider
como
as being
principio de
relevant. Currently, we
progresividad de derechos
prioritize the
ambientales,
principle of the
especialmente en
progressiveness of environmental
coordinación
rights, and
estratégica
especially
con los convenios
non-regression.
internacionales.
These rights are
Enunciado
essential
y
for
señalado
international and
que nuestra
international
Constitución
commitments. As
nacional
we've
y la
mentioned,
línea
this
del carácter
jurisprudence is constitutional
proporcional de los
and
convenios
is
internacionales y
super
hace el
constitutional. as regards international conventions. Not only that, but we also have all the decisions from the Inter-American Court of Human Rights in all environments, not just regarding environmental decisions, but ever since the 90s, we also have, for instance, issues regarding children, and this is a materialization of the intergenerational rights. And we also have citizen participation as with a wider vision, saying that citizens can bring accusations forward. So I'd like to have an interesting case, which is a relatively recent jurisprudence from the first group of the International Court, where was an annulment for the availability of hunting of 3 species of hammer sharks. This was determined using specialists and international conventions because a few of these shark species are in extinction. Not only do we consider that a shark has its own rights, but this was also aligned to our jurisprudence, but we also considered the nullity of this decree, which allowed for the fishing of these species. And now we're protecting the species. And there was an interest of some of these companies for the sharks because they wanted to just have their fins. These species are almost extinct. In Costa Rica, we undertook a lot of effort to protect these hammer sharks. You also know that we have a lot of biodiversity reservations, national parks, and we have species in these places. These are also places where we can host these hammer shark species. So we catalog them, and so we also looked at the international nuance and different pacts, and we combat organized crime in fishing these sharks. And this brought a lot of priority in a wider view from the moment where we started discerning this. Unfortunately, we know that a lot of our countries suffer from illegal extraction, illegal mining, and we know that this doesn't happen only in one country, but in many other countries. And we're already fighting to make sure that this is dealt with in an integrated fashion so that we can have the protection of the environment for everyone. Considering citizens and companies, anyone who wants to be involved can be involved, but we also like to highlight that as judges, we can't be activists. We need to take care of our own competencies of being able to interpret in an evolving manner the jurisprudence and the laws regarding climate change. And obviously, in many of our countries, the environmental legislation is not as advanced as it should be. In our country, we have very modern laws, but we also have other laws that need to be updated. But throughout time, we need to consider what is most important in the norms, having a wider reaching view and understanding that we're not just local judges, rather we are judges who can impact the planet. And we've seen in this forum a variety of different statements from different countries, different experiences, which we're able to incite and bring advocacy to different countries. And these are not directly from people who are directly involved in these cases, rather they are part of this wider group. And we have a environmental justice commission. This is a space where that is available to all of you. We have official documents on environmental law, which are guiding light when we are ruling on these cases. Why do I like to highlight this? Because these are not doctrinal principles. They're principles that are derived from international environmental conventions, and which are therefore constituting our language as a common language of the global community of states. This is why I think that a space like this is a space for learning, for best practices in the environment in different countries and in their jurisprudences. Obviously, this is jurisdictional, and it deals with what we have internally in our country. I'd like to thank the organizers for such an amazing leadership, and of course, the leadership of Justice Herman Benjamin. This is why we are involved in this space to talk about climate change in our countries. Of course, I would also like to mention that we had sentences which were very positive, in which we're able to establish timetables for actions. These are rulings which are focused on the expertise of our specialists who can tell us how to use these environmental resources or how we can recover resources that were damaged. And based on that, we also had a variety of climate catastrophes in our countries, especially in countries in the tropical regions like my country. So I'd like to greet all of you and to say thank you. I'm available to answer any sort of question or comment.
Thank you, Justice Vargas. And now we'll open up the floor for any questions. I see a question from Carlos Jose Vargas Eduardo. And the question is, how can courts act to ensure that access to safe drinking water and sanitation is upheld as a fundamental right rather than just a policy goal, especially in the face of environmental setbacks and the climate crisis that exacerbates water scarcity for vulnerable populations? So water is a critical issue now. Just wondering if Justice Prakash or Justice Vargas has any insights on water cases.
Yes, so for India, in the perspective of the Indian scenario, I can say that the courts here, they have recognized the environmental issues, especially the right to have the clean drinking water or water preservation, especially in reference to the daily need, is recognized as a fundamental right. So what happens, there are cases which come up before the courts. We are dealing with a case where the issue has been raised that a particular area in a city was not getting the clean drinking water. So they came to the tribunal. Now we are examining it. We are directing the authorities to ensure whatever there was a leakage or mixing of the contaminants in that water. So we are looking at it, and the courts have recognized the right to clean drinking water as a fundamental right. And water scarcity, that's another issue. That's the surface water, the groundwater also. The groundwater is depleting. So these are the issues which are being dealt with the court. There is emphasis on water harvesting. The directives are there issued by the court to ensure that the rainwater is harvested so that the groundwater is recharged. So these issues are coming up. The courts are, especially in India, they are playing an active role. The directions are issued. The government is, in fact, asked to frame the guidelines for it. And the court also monitors it in the different orders and the judgments to ensure that these guidelines are properly implemented, the groundwater is recharged, the issue of water scarcity is taken care of. So we have a number of judgments on these issues. Thank you.
Thank you, Justice Prakash. Justice Vargas, would you have any contribution on this area?
Sí, muchas gracias por la pregunta. En la Constitución Política de Costa Rica se establece expresamente que el derecho al agua es un derecho humano. Y no solamente
Água é direito humano. Water is a human right, not just water. So we have we have come up with a guide for potable water so that the country has drinking water for people. This was not a casualty. This was expressed in the courts so that the right to the consumption of drinkable water in cities. So in certain cities, companies had been prioritized over people. And this is a fundamental right that we want to put this, and hopefully in our country, water is abundant. However, we have some trends of desertification in certain areas, and we are projecting these for the future. We have a project called Seeding Water, so that people in this region may have the ability to raise cattle and to have resources. So, for instance, to grow trees and other things that we consider essentials. So there is jurisprudence towards this hydric resources. And we've been giving support by local support, and there are law projects for these areas. We're in the process of implementing them, which is called the integral application of water resources. This is an essential question because we have been making projections for the future to prevent the absence of such an important resource.
Well, thank you so much. Unfortunately, we don't have time for questions. We need to start the closing panel in a few minutes. And I also need to leave in order to chair the special court, which is our court, Bambang. Therefore, let me thank Christina Pak for the excellent job as usual today as chair of the panel. Tomorrow, we will be releasing the videos of the different panels. And today we will be sending photographs of our proceedings. Let me also thank the two speakers, our colleagues Damares Vargas from the Supreme Court of Costa Rica and Justice Prakash Shrivastava, previously from the Supreme Court of India and now the President of the National Green Tribunal of India. It has been a great pleasure, and I learned a lot from you. The next panel, which is the closing panel, is chaired by a dear friend and colleague, a scholar, John Scanlon, who is the president of the International Council of Environmental Law. He has worked in many positions nationally in Australia, but also internationally in the area of environmental law. He worked for UNEP. He was executive secretary of one of the most important international conventions on the protection of the environment, CITES. And John is someone that is well known globally. John will be the chair. We have two fantastic speakers. First, my dear friend, colleague, many years, Justice Edson Fachin. Justice Edson Fachin is the Deputy Chief Justice of the Brazilian STF, which is the Brazilian Supreme Constitutional Court. Previously, he was the president of the National Electoral Tribunal, and he is one of the most celebrated scholars, civil law scholars in this country. He is not just in private law, he's in public law, in constitutional law, someone that writes beautifully, and even more important, is attuned to the social and environmental needs of society. The second speaker is also a scholar, well-known scholar, Professor Christina Voigt, who is the chair of the World Commission on Environmental Law, a distinguished professor at the Faculty of Law of the University of Oslo. Christina is a prolific writer, as Justice and Professor Fakin, and is someone that we all admire very much. You see, we couldn't end this two-day symposium with better speakers that are well regarded, that write a lot, and write on environmental law, but also with great knowledge, in-depth knowledge of the foundations of law. With that, John Scanlon, you have the floor.
Thank you very much.
I forgot to say, John, again, that we have interpretation in English, Spanish, French, Portuguese, and Mandarin.
Fabulous. Well, thank you very much, Chief Justice Benjamin, for your very generous introduction to all of us. It's certainly a great honor to be invited to be a part of this event, and the International Council of Environmental Law is very proud to be a co-sponsor. Colleagues, I'd like to start by referring to a famous phrase by Dostoevsky, and I'm sure it's known to all of you. Beauty will save the world. It's not a simple statement about aesthetics, rather it's a complex idea about the power of beauty to inspire and uplift humanity. And it was further popularized by the singer Nick Cave in his song Nature Boy. Chief Justice Benjamin opened our online event yesterday and today by referring to the beautiful images to his left and to his right by the late and great Sebastião Salgado. And it was both a fitting tribute to an extraordinary human being and his family, and a perfect way to get us underway. Thank you, Antonio. Since then, assuming my maths is correct, we've heard from senior judges from 11 countries, coming from the global north and the global south, across 11 time zones and in 5 languages, ensuring that this event has provided a broad array of perspectives and that it is available to the widest possible audience. We've also heard from leaders from the Climate Change Convention Secretariat, the UN Environment Programme, the Asian Development Bank, and from the political leadership in Brazil that will be leading us so ably at COP30 in Belém. What's clear from the past 2 days is that Brazil's extraordinary leadership is not confined to the political sphere, but it is also evident through its judiciary. Now, we know that the work of judges in this area has been dragged into the ideological political battleground. Now, what better way to respond than to hear from the judges themselves across multiple jurisdictions about how they approach climate change in their work in the context of their own political systems. It's been enlightening, and this has been a unique and groundbreaking event. Pulling together an event like this requires someone with personal credibility, charisma, and boundless energy. And in this regard, we're indebted to Chief Justice Benjamin. And I first met him 25 years ago. And across all the places I've lived, worked, and visited, I have never met anyone quite like Chief Justice Benjamin. And we are indeed fortunate to have him in his leadership role at this critical point of time. Now, through Chief Justice Benjamin's unique approach, as we have discussed judges and climate change over the past 2 days, we've also gained invaluable insights into convergence across and between continents, countries, disciplines, conventions, and sectors in advancing our collective efforts to tackle climate change. And we now have the opportunity to hear from our 2 wonderful final speakers, both of whom bring a wealth of knowledge, experience, and expertise to this event. Now, they've already been introduced to you by the Chief Justice, and I am under very strict instructions from him not to go back and read their bios, to allow maximum time to hear their closing addresses, and to ensure we can finish well within time. And I'm going to follow these instructions to the letter. Now it's my great pleasure to now invite Justice Edson Fachin, the Deputy Chief Justice at the Supreme Constitutional Court of Brazil, to address us. Over to you.
Thank you so much, Mr. President. First, I ask for permission to speak in Portuguese, and I am sure that we understand. And eu gostaria de saudar, então, nesse momento,
I'd like to thank you, the illustrious Minister, Herman Benjamin, Chair of the Supreme Court, and here, the organizer of this marvelous event that we have. I also would like to greet the chair panel, John Scanlon, and also Christina Voigt, also a speaker at this moment. As we have noticed recently, the present panel is the final one. So I would ask you to go straight to three major points in the worrying current scenario, three premises that I believe that are essential in the judicial ways and the controversies related to the climate. First, the right to climatic security is a fundamental right. Second, there is a worrying and constable circumstance in this area that we can denominate a state of unconstitutional things, climatic related. Third, to the judicial powers of adequating judicial and to the solution to litigation, climatic litigation. So I'd like to treat specifically to each one of these ideas. Now, with regards to fundamental rights of climatic safety, security, I'd like to remind that Brazil in the Constitution, Brazilian Constitution reserves the Article 235 expressly states that the fundamental right to a balanced environment, so that the legislator that constitutes that qualifies this as essential. This is diffused as an individual right, and we should preserve and maintain this as an intergenerational right. From this, we have a judicial. I believe that this is coherent photography to my colleague, Christina Voigt, translated as the ecological rule of law, and also that has been worked on by the Supreme Court, specifically with Herman Benjamin, and in August of 2022, it's now possible to talk about a fundamental right of a rigid climate. In this sense, as a minister, as a justice, I have ruled that not complying to this fundamental right number 708 in this action of state omission in relation to the national fund known in Brazil as Fundo Clima. I've also consignated that this vocal vote and the comprehension of a climatic emergency for all these answers and facing them, this will decide the future of humanity. Climate quality is a fundamental right, one of the most valuable ones, because it presupposes the existence of human development as well as the climate integrating that we can call a minimum existence right. Human survival depends organically in saving the environment. Here, therefore, this minimal existence, this minimal vital, is no less than the soul, the minimal existential climate. So we need to pressingly be on alert to the integrity of the climate, serving as a barrier to secure any judicial status to a literal continuity of human life, to start something that is a verified success, deliberate or not, of the state and society, so that we must realize and be on the watch for rights that integrate this minimal climatic existence as an example of a healthy lifestyle, democracy, and citizenship. Before this situation, which is very critical and profound notice until now, that now this brings us to a brotherhood on the planet in a transversal perspective, be it on the public sphere or relations among private businesses. Climate litigations must be realized as a state right. So this makes it unprecedented that the reading and rereading of judicial institutes may be then substantial or objectives, be individual, be collective. Our solidarity over a climate project for the future. We need a conception that imposes on all humanity the obligation to promote and defend the well-being of the climate. Thinking of future generations, this preoccupation that is this essentially intergeneration. We have known from the Broadland report that solidarity in the building and conduction of this common future brought to the center of the discussion at this moment matters such as global warming and climate change are harmful, that they come from a climate emergency that we live through today. Such subjects in this order of the global manners are factual for nowadays in our reports for a common future. The Stockholm Convention to this edition in Brazil of the law from 1968 into 1981 that brought this national policy of the climate of the environment to our constitution. This is number one. Number two is the existence of an unconstitutional state of climatic things. Understanding that climatic emergencies in a conjunction is generally violated. They are structure and fundamental rights, especially to the right of climatic security. The environment must be logically balanced. There is a non-motion, general non-motion from the public power that is wrongfully due. The well-being of the environment is incidental. We need protection for the climate. I have no doubts that the vulnerability of this fundamental right ends up getting to other judicial subjects. So this, I believe that we need to keep a straight bond to civil and such countries as Brazil, especially from the lack of integrity, puts to the level of the inequality among Brazilians with the idea of a democratic regime. So these impacts go beyond the connection to healthcare, education, deficiency, and the access to information also are characterized by this state of unconstitutional things that hit directly the political exercise from people. Therefore, and the hypervariability of certain I now turn to the third point. In it, it emphasizes structural transformations usually considered the search for a solution to these situations must be even more profound. I highlight the following fact. These structures that are usually in this dramatic picture that we live in today should be deeper, demanding from the public and from society autonomous protective culture as a justice, that the judicial power is the destination promoted by this superior court. We have a potential litigation to have a proactive latitude from the powers, which is conveyed by theory, concept, and practice of these structural processes. The technical capacitation, Brazilian judges must, without fear, face climatic litigation, equipped with the ritualistic placidity conferred upon them by the structural process and before it by the collective process. National and international jurisprudence is already moving in this direction. There are two recent precedents in which the fundamental right is ATPF number 100 judge in 2022, in which endorsed the existence of a constitutional duty for the climate to combat climate change. In addition, many judgments in the Inter-American Court, in the case of the community Mulyono versus Suriname, was the protection of the right to life, a project and reparation for spiritual damages suffered by a traditional community. And this court also indirectly safeguarded climate rights. Subsequently, in the case Lagos del Campo versus Peru, whose merits judgment was delivered, unprecedented the direct inquiry of environmental rights. In 2018, the case Cusquil, Pivaral, and others versus Guatemala, which was consolidated for the indigenous communities members versus La Asociación La Cortera versus Argentina, sentenced in 2020 during the pandemic. This conjunction is in line with the so-called greening the movement of greening, the protection of human rights in regional systems, which I firmly believe that the Brazilian judiciary is capable of progressively moving towards the best protection of climate rights. And the judicial power will have a key role to have a safeguard of the environment. I conclude my contribution to this debate with the words of Pope Francis, the encyclical Laudato, that has been for 10 years. Said the Pope, the climate is a common good, a good of all and for all. For it's because of this survival, not just physiological, but also democratic, that we are dealing with. Thank you.
Thank you very much, Justice Fachin, for sharing your most interesting insights with us today. And we're now going to move to our final speaker, my dear friend and colleague, Professor Christina Voigt. She's with the Faculty of Law at the University of Oslo and is chair of the IUCN World Commission on Environmental Law. Christina, over to you.
Thank you so much, John, for this kind introduction. I have to say that the IUCN World Commission on Environmental Law is a very proud partner of this event, Judges and Climate Change. And I've been listening in all day today and a little bit yesterday, and I can just perceive the very, very constructive and fruitful discussions that have been going on. I would also like to thank my co-panelist, Minister Fachin, for his excellent intervention. I will pick up on some of the aspects that he mentioned. Now, why is IUCN World Commission so proud to partner in this event? I think that the discussion among and between judges and diplomats and policymakers is incredibly important. I think, John, you mentioned something along those lines in your opening remark. It is important, but the interesting fact is there really is no forum for a discussion to take place. There is no other forum if it wasn't for this and other events organized by the Global Judicial Institute on the Environment and its president, Chief Justice Antonia Herman Benjamin, together with partners. So this is an outstanding opportunity to have that exchange, which otherwise most likely wouldn't take place, but which is incredibly important because the climate crisis requires an all hands on deck approach where all decision makers and judges and diplomats and experts are needed. There is also a cross-fertilization between these different discourses, as I will try to go into my intervention. And there are some feedback loops, some normative feedback loops from one of these discourses to the other. The implications of the findings by international courts, for example, for the climate negotiations, and their implications of international treaties for domestic climate litigation. So there are these feedback loops that we see happening time and time again, and many of these speakers have spoken to them. Now, this also leads me to the topic of my talk, which is climate litigation at international courts. I'm well aware that most of the speakers have spoken about their national jurisdictions and what's happening there in the context of climate litigation, but international courts have so far been only mentioned by a few speakers, but I'll try to draw a little bit more comprehensive picture of what is happening at the level of international courts. Because these are special times. We are experiencing special times. For about 2 decades, we've been witnessing an unfolding wave of domestic climate litigation, where many domestic courts, national courts at all levels at the domestic judiciary have been involved in different legal questions with respect to climate change. But what is new now is that for the last 2 to 3 years, we are witnessing that climate change has become an issue that international courts are concerned with. And both in the context of contentious cases, especially with regard to human rights, and then with respect to advisory proceedings. So in the following, I will briefly address three things. I will first explain the landscape of climate change litigation and international courts. I will then try to give a little bit of detail on the existing case law and, most importantly, what is yet to come to keep us all at the edge of our chairs. And then finally, I'll provide some reflections about how international courts' decisions and judgments and advisory opinions may intersect with the climate negotiations, because we had in the beginning of yesterday's session, the incoming president, or the president of the incoming COP30, as well as the UNFCCC Secretariat representative by Simon Steele. Now, first to the landscape of international courts of climate change. As I mentioned, we have seen that climate change has reached the level of international courts in two different ways, in the way of contentious cases and in advisory proceeding. When it comes to contentious cases, we've so far only seen this in the context of regional human rights courts, in particular European Court of Human Rights. And we've already heard yesterday about the Klimaseniorinnen judgment, Klimaseniorinnen against Switzerland by Justice Luc Laverdus, and so I will not spend much time on it. And today some speakers also mentioned that very important judgment. But there are many more cases to come. They're in the pipeline of the European Court on Human Rights. There are about 10 to 12 cases that are still waiting to be decided by the court. So we will see much more coming out of that court on the relationship between climate change and human rights. But that one judgment that came out about a year ago, last year, and on the 9th of April 2024 in Klimaseniorinnen against Switzerland, was a very, very important one, because it concerned human rights violations due to insufficient state action on climate change, here in particular by Switzerland. And it was the first authoritative judicial statement that directly linked human rights protection and climate change. And here it found a violation of the positive obligation under Article 8 of the European Convention that concerns the right to private life and family life, which was not fulfilled by Switzerland. Very briefly, there are two very important points from that judgment. There are probably many more. I just highlight two. First, that the European Convention does not mention environment or climate change anywhere in its text. It's just not part of the European Convention on Human Rights. So the European Court interpreted the convention in a dynamic fashion in the context of climate change, and interpreted into the existing human rights obligation the context of climate change. And secondly, that interpretation happened in the light of the Paris Agreement, another international agreement that was used to give content to the right to family and private life, in particular the goal of net zero emissions by around 2050. The court would not have been able to make this statement if it hadn't been for the Paris Agreement, in the light of which the European Convention was interpreted. Very important. So second, I turn to the advisory proceedings before international courts, and this is perhaps the most exciting things that are yet to come, because we have currently four proceedings, advisory proceedings before international courts. We have two before regional human rights courts, that is the Inter-American Court on Human Rights and the African Court on Humans and People's Rights. And we have one before, or had one before the International Tribunal on the Law of the Sea, which already was issued. And then, of course, the pinnacle of it all are the advisory proceedings before the International Court of Justice. Why is this so interesting? Well, for many reasons. First of all, at the very core, the questions put to those four international tribunals are very similar. They really, at the very core, concern the question, what do states have to do to address climate change, either in order to protect human rights or to protect the marine environment or to protect the climate system per se? But the core of the question is really similar, if not even the same. And the second point here that I just want to mention is that there, of course, is no formal relationship between those four courts. They could come to the same or similar conclusion, but they could also come to different conclusions. I'll come back to that at the very end. What kind of risks we also may face by having four parallel proceedings. Now, just to give more detail on what we already have from the international courts in terms of advisory proceedings, the first advisory opinion is already out. It was issued by the International Tribunal on the Law of the Sea about exactly 1 year ago, on the 21st of May, 2024. And that is a very important advisory opinion because it establishes that human-made anthropogenic greenhouse gas emissions are pollution of the marine environment. That's a very important signal by the tribunal. And because greenhouse gas emissions are pollution of the marine environment, several obligations under the United Nations Convention on the Law of the Sea, over which the tribunal has jurisdiction, arise, including the obligation to prevent, reduce, and control pollution of the marine environment under Article 194, paragraph 1 of the Law of the Sea Convention, according to which all parties need to take necessary measures. And again, the core question here is, what are necessary measures to control, prevent, and reduce pollution from greenhouse gas emissions? And in this context, the tribunal again referred to the Paris Agreement as international rules of standards in order to inform the obligation of states under UNCLOS to take all necessary measures to prevent, control, and reduce pollution of the marine environment. So it used the Paris Agreement as an interpretative element of the obligations under the Law of the Sea Convention, and it used from the Paris Agreement in particular the temperature goal and the emission pathway and timelines, again, reaching net zero emissions by 2050. This, again, is important because UNCLOS established, ITLOS, the International Tribunal of the Sea, established independent and parallel legal obligations to those under the climate treaties. And it also carried out a systemic integration between UNCLOS on the one side and the climate treaties on the other side. Now, I will then move on to my final point, and that is to give some personal reflections on that landscape of international climate litigation that we are seeing. As I mentioned, there are 3 more advisory proceedings pending, one from the Inter-American Court on Human Rights, which had hearings amongst other places in Brasilia last year, but also from the African Court on Human and People's Rights and the International Court of Justice. I'll briefly, in my last 3.5 minutes, will address 5 brief reflections. The first one is, as I already said, the legal questions put to these courts are at the very core very similar, which means that these courts now have the opportunity to create harmony and consistency in international law by interpreting the different instruments that they have in front of them, either as courts of special jurisdiction or general competence like the ICJ. So they could create harmony and consistency in international law or not. That still remains to be seen. All depends on the outcome. We have the example of the International Tribunal of the Sea, which created that harmonious understanding, but we still have to see what the other 3 courts say when they come with their opinions. If they create different standards with respect to climate change, that could be the risk of kind of standard shopping of states, which then may want to feel inclined to lead or to follow the standard that is most appropriate to their national circumstances, whatever they might be. And that again could undermine the international negotiations on climate change, which already are most then difficult enough, as you, John, have recently written about in terms of need of a reform of these international negotiations. So in my view, as we've seen from the 2 courts that I mentioned already, the European Court on Human Rights and ITLOS, standards must be based on the Paris Agreement, otherwise they would lead to all sorts of differing views. Second, The outcome may strengthen the negotiation position by some states, but it may not strengthen those by others. We have seen very broad scope of arguments presented to the courts, and this will most likely be used in the negotiations to underline some positions by some states and to undermine the position by others. So that's necessarily a linkage between those advisory opinions and the negotiations. The courts are asked to clarify norms of international law, and that may require going into much more detail than what, for example, the Paris Agreement provides us with, for example, on compensation for loss and damage, or on the finance obligation. And again, that may have a feedback loop, positive or negative, with the international negotiations. My fourth and next final point is that the findings by these international courts, of course, may and hopefully will impact also climate cases in domestic courts. Advisory opinions are not legally binding, but the expectation is that many judges will look at the authoritative statements by international courts when deciding their cases in national courts. And my final point is that it is hoped that the result supports and not hamper climate negotiations. But for many states, the advisory proceedings seem to be the first step towards contentious cases. We don't have yet a state-to-state contentious proceeding, but that might come. And the question is how this will impact negotiations, and this is still unclear. We all know climate change is a global collective action problem and needs to be addressed by cooperative action and maybe not through the course of contentious proceedings. So the advisory proceedings must find a careful balance between clarifying the law and pushing boundaries. An advisory opinion that is too wide could undermine the credibility of international tribunals and may not be considered legitimate or may not be followed by states. But if it is too narrow, it may not have any practical impact. So we're waiting with great anticipation of what is coming from those courts, because literally the ball is in the judges' court. Thank you so much, John, and back to you.
Thank you, Christina, and a lovely point to finish your presentation on, and really, invaluable insights, in particular, given how closely you've been involved in these processes. So really appreciate that. Now, we do have a little bit of time for Q&A. I have spotted 2 questions, or maybe another one's come up. Yes, I've seen a couple of questions. There is one from the previous session, but I think it's still relevant for this one. So I'm going to start with the first question I can see. It's from Mohammed Shokri, and he asked, to what extent can courts review climate or environment-related decisions made by administrative authorities when such decisions fall within the scope of broad discretionary powers? In such cases, how can the judiciary strike a balance between respecting administrative discretion and ensuring environmental protection? Who would like to take that one? Christina, Justice Fashin? Christina, I think you're going to go first.
Yes.
Oh, Justice Fashin, yes.
We can listen first to Professor Christina. Gladly.
Well, I'm happy to listen to you too, but I think the issue of wide discretion, administrative discretion, is a challenge in many of the climate proceedings. I can only talk from my example here in Norway, where the administration has very wide discretion, and it's very the courts have a very restrictive possibility for judicial review where there is that discretion. But I think what we're seeing now is that both international law, of course, helps to review that discretion where it's possible. International law, not necessarily directly applicable to domestic proceedings, that is only the case in monist systems, but as guidance for what the state has committed itself to, and which then also needs to be reflected in the exercise of discretion by state organs or subnational organs. But I think, as I just said, these advisory proceedings and the outcomes of these advisory proceedings in contentious cases are also a very important element for domestic judges in exercising judicial review, because they are authoritative statements of the general travel of direction, which then can also be reflected in the decision of, or in the review of domestic cases. So I think this is another element that domestic judges will look for and will use in domestic climate proceedings.
Thanks, Christina. Justice Fachin?
Yes, as I spoke in Portuguese, I ask you to respond in Portuguese.
Perfect.
Essa é uma questão importantíssima e eu vou pegar ângulo que dialoga.
Essa é uma questão importantíssima. So I'll take this angle from Professor Christina when she exposed the risks and possibilities from the announcement from the courts. In fact, we need to be careful so that the justices and courts may not have an excess of ambition to see where they could go with regards to the subject, to know the extensions of their powers before other spaces that are reserved to legislators, to managers. So this is a vital theme that deals with the balance of the different powers among the legislative powers of judicial decision and executive, who are responsible for doing this. So this is a heated discussion in Brazil among us. There's even a judicial activism. For us, it is a jurisdiction of climate justice. So this went from the judicial because of the omission from the other powers. So the legislative was seeked out because of the omission of the powers. Even though we are judges, it's fundamental to be cautious so that not to usurp the functions from the other powers. That is, it's important judicial action. It's important that these possibilities are put before the courts. Professor Christina made reference, including to an announcement from the Hamburg court from the sea. And it's fundamental as well, so that courts also have coherence, so that judges keep themselves coherent to a common action among the diverse powers, so that what comes from the judicial is not interfering in the advancements that we should have with regards to climatic protection. This could not be an obstacle. We need to have a bridge so these advancements can be made. Thank you.
Thank you very much, Justice Fachin, for that. I have two more questions. I think we have time to take both of them. I'm going to go to the first question we have. It's been written in both Portuguese and English in the Q&A box. Comes from Carlos Jose Vargas Eduardo. And he says, I'll read the English version. Considering that the climate emergency structurally violates fundamental rights, as pointed out by Justice Edson Fachin, to what extent can universal access to safe drinking water and sanitation be recognized as an essential element of the climate-related existential minimum, particularly in favor of hyper-vulnerable populations? And he goes on to say he appreciates the opportunity to engage. Christina, I'll start with you again.
Okay, yeah, I saw that the question was similarly formulated, slightly different and directed to me. I think we will see from the very first linkage between climate change and human rights by the European Court on Human Rights. We had a previous announcement by the Human Rights Committee on the need to adaptation action, but now we have the European Court on mitigation action. I think from that first linkage between human rights and climate change, we will see in the future much more granularity on particular human rights, like the right to water and to sanitation and the right to food and education. I mean, basically all human rights are impacted by climate change. And I think where we probably will want to look for more of that granularity is from the Inter-American Court on Human Rights. As we all know, that has been a rather progressive court traditionally on establishing the existence of a human right to a healthy environment. And now we all await the advisory opinion from San Jose, from Costa Rica. And I'm pretty sure that this advisory opinion interpreting the American Convention on Human Rights in the context of the climate emergency will give much more detail on which human rights are impacted by climate change, what are the obligations of states to protect them, what needs to be done. And it would surprise me if water and sanitation would not be mentioned. I'm pretty sure we will see something coming from that court. And once it is out, other courts will follow up. I think we see this cross-fertilization, if I can call it like this, by different judges, different courts being inspired what other courts have said. So I think the judgments, as we've heard now for the last two days, make this global journey and appear in different judgments all around the world. And I think we'll see the same both horizontally and vertically from the advisory opinions by international courts.
Great, thanks, Christina. And you've also answered his related question at the same time, I think. So thank you very much for that. Justice Fachin, over to you.
Okay, thank you. Eu considero que
All right, so I consider that Professor Christina's answer was more than sufficient. I would just like to add a further element, since the question was so well formulated that it has the answer in and of itself. That is, in fact, the minimum climate existential does include access to basic sanitation and drinking water. And the connection of this right to drinking water and basic sanitation happens through human rights, as Professor Christina had already mentioned. I would already like to add a debate, which is of knowing that given the omission of public policies in actually implementing access to drinking water and implementing the right to basic sanitation fully in their population, if these omissions may be asked for in the courts, are they demandable judicially? That is, are we seeing a fundamental right in character that can be demanded? This might be the debate that comes after this question that was responded. In certain cases, I believe that the judicial sector can indeed demand this when there's a systemic and structural omission. Yes, the judiciary can do this without taking over the functions of legislators or the executive branch. That is what I would add as an additional element to that answer. Thank you.
Wonderful. Thank you very much for that. And just rereading the questions, I think that the answer that's been given by both of you addresses both of the questions that were put in the question and answer box there on Zoom. So thank you for that. That concludes all of the questions that I can see, unless I'll just do a double check. Yes, that looks as though we've concluded the questions. So let me express my most sincere thanks to both of our speakers, Justice Fachin and Professor Voigt. Fantastic session, really valuable insights, great answers to the questions, and you've certainly ensured that this two-day event has finished on a high. I would now like to formally hand back to Brasilia And I'd like to hand back to Justice Paulo Sergio Domingues. He's from the National High Court of Brazil, and he will be closing our session and our event. Thank you very much.
Well, thank you very much. I'd like to thank Mr. John Scanlon for this great work in this panel, and also Professor Christina Voigt from the University of Oslo. And also, I'd like to congratulate and thank Justice Edson Fachin for his participation in this panel. On behalf of Justice Herman Benjamin, I'd like to congratulate all the participants of the panels from yesterday and from today. This has been an amazing seminar. All the panels are very interesting, and they presented the challenges we have in front of us in the next future, in all the cases that people present to us in our courts worldwide. Justice Edson Fachin, we know that this is a topic in which you deposit your concerns also, and we know that the tasks you will have before yourself in the next years are really great. The challenges are amazing, and we know that you will be concerned in addressing these questions. These issues will be topics in the COP30, when you will be already the president of our Supreme Court. And also, you know that we will have next year a meeting of the Supreme Courts of Latin America, under your term as the president of our Supreme Court. We deposit great hopes in your term as our Chief Justice in Brazil. So again, on behalf of President Herman Benjamin, I'd like to thank all the participants, and I'd like to greet all the people that attended the seminar, and also all the people that worked in the organization of this seminar that made possible for us to have a great work here and to learn a lot from our panelists. Thank you very much. So now I think we can declare the closure of our works, and I thank you all.
Thank you.
Recording stopped.